first and then?
Yes.
One.
Is that what we agreed upon?
And the last one?
Yeah.
Kramer.
Sixth and seventh and fourth and five.
Keep that.
Okay,
I didn't do it.
Three.
that's fine.
Four.
Okay.
Okay.
Okay, my phone.
Oh, yeah, got it. Thank you, sir.
No problem.
Mark, you there?
See the shadow?
Good evening, everyone. Call to order the meeting of the Board of Adjustments for January 24th, 2018. We have the roll call, please, Kim.
Chairman Elliott,
Here?
Mr. Obowski,
Here.
Mr. Burris,
Here.
Mr. Eisner,
Here.
Ms. Turner,
Present.
and Mr. Glemser is our alternate.
All right, thank you. Let's first silence our cell phones, please. When you get to the podium, if you would state your name and address. We have 4 items on the agenda tonight. Under the rules of procedure, the chairman is permitted to deviate from the items listed on the agenda for exigent circumstances. There's been a request, 2 requests actually, to change the order. And with the consent of everybody, we're going to put number 6 first, 38 Kramer Avenue first after we get through our procedural items. And then number 7, 123 or 119, depending on how you're counting, North Florida Avenue. That'll be second. And then Village Drive third and Athenian Way fourth. Is that okay with everybody? All right, thank you. Appreciate that. The next item on the agenda is election of officers. Can we put that at the end, please? Is that all right? And also the minutes, normally it comes at the beginning. Per our rules of procedure, we can't change that without the commissioner's consent. So it has to be at least listed as first, but let's put the minutes back at the end if we could. All right, so then let's start off with our quasi-judicial announcement from legal counsel, please.
This is a quasi-judicial proceeding where the Board of Adjustment acts in a quasi-judicial rather than a legislative capacity. At a quasi-judicial hearing, it is not the board's function to make law, but rather to apply law that has already been established. In a quasi-judicial hearing, the board is required by law to make findings of fact based upon the evidence presented at the hearing and apply those findings of fact to previously established criteria contained in the Code of Ordinances in order to make a legal decision regarding the application before it. The board may only consider evidence at this hearing that the law considers competent, substantial, and relevant to the issues. If the competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has met the criteria established in the Code of Ordinance, then the board is required by law to find in favor of the applicant. By the same token, if the competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has failed to meet the criteria established in the Code of Ordinance, then the board is required by law to find against the applicant. Are there any members of the board wishing to disclose any conflicts of interest or ex parte communications this evening?
Yep.
Seeing none. Anyone wishing to speak this evening, if you could please stand and raise your right hand to be sworn in. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? So sworn.
Okay, thank you, everyone. Way we normally work, the staff will present its case, and then the applicant can present its case. There's cross-examination. Anybody can cross-examine if you like. Any comments from the other side? And then the Board of Adjustment can ask questions from the staff or from the applicants. Any public comments are next. And then rebuttal by either side, applicants or opponents. And staff can rebut, and then we close the public hearing and have the commission or the board pass a motion and consider that motion. If on occasion we are allowed to reopen the public hearing if anything the board says is of some concern to the applicants, and just raise your hand and we'll probably allow you to speak even though the public hearing has been closed, as a courtesy to everybody. So let's start off with number 6 on our agenda, 38 Kramer Avenue. It's a variance to reduce the front yard and rear yard setbacks for a single-family dwelling. Who's going to make the presentation?
Pat McNeese, Principal Planner. As mentioned, this is an application to authorize a variance to reduce the front yard and the rear yard setback in order to accommodate a single-family residence. The location is 39 Creamer Avenue. The applicant is Equity Trust Company. This is a property built in 1951, occupied by an existing dilapidated structure. The applicant wishes to replace that structure with a new residence. The current residence is non-conforming with respect to front and rear setbacks. If you would refer to page 2 of the staff report, you'll see a table that compares the district setbacks, the setbacks for the current structure, and the proposed setbacks for the new structure for front and rear. This property is has an irregular shape. It's 125 feet wide. It's a good deal wider than it is deep. It is, if you're looking at the property from the street, it's about 87 feet deep on the north or left side, and then it goes out to 109 feet deep on the south or right side. At the same time, as you're going from northwest to southeast, the property has a sloping topography with a significant downward slope at that southeast corner. So that physical condition sort of pushes or limits the building area up to the northwest portion of the property. The review criteria for variances are listed. We can go over those or answer any questions in detail on that. This proposal would continue the nonconformity, although it would reduce it by about 6%. This application has been properly noticed. There were no public responses received. Staff recommended findings of fact for the record, starting on page 4. Number 1, the applicant wishes to demolish an existing dilapidated single-family residence and build a new residence on the subject property. Number 2, the existing single-family residence is non-conforming with respect to front and rear setbacks. The newly proposed residence would continue this non-conformity, but would reduce it by about 6%. Number 3, the subject property is irregularly shaped and has a steep sloping topography that makes it unique when compared with other properties in this zoning district, and also limits options for laying out a site plan or a single-family residence similar to the existing residence and the neighboring residences. It is concluded that the requested variance does arise out of physical and environmental characteristics of the property that are unique to the zoning district. Number 4, the condition on a property for which the variance is requested has not been self-created and is not the result of an action by the applicant. The condition is related to the shape and topography of the property itself. Number 5, literal enforcement of the front and rear setbacks would prevent construction of a single-family home of a size and layout that meets minimum district requirements and is comparable to single-family homes located elsewhere in this zoning district, and would therefore deny the applicant reasonable use of the property. Number 6, granting of the variance would not confer on the applicant any special privileges not allowed for other properties in this district, either with respect to the use or the layout, since there are several single-family residences in the immediate area with non-conforming setbacks. And number 7, granting of the variance would not injure or impact the rights of owners of affected properties or create a nuisance or otherwise substantially negatively impact surrounding properties, since surrounding properties are occupied with single-family homes, several of which have nonconformities similar to the subject lot. Staff recommends that the request meets all of the review criteria established in the Land Development Code, specifically Section 215.02B, Staff recommends approval of a variance for relief from the minimum front yard setback and the minimum rear yard setback. Do you have any questions?
Thank you very much. Very fine report. Mr. Hoffman, you missed to make a statement? The applicant? Yeah. You're entitled to cross-examine and make your own case if you'd like.
Make my own case. I'm Ed Hoffman, Hoffman Architects, 29 West Orange Street, Tarpon Springs, Florida, just down the street here. I think they've done an excellent job stating our case, and unless there's, questions, I'm available. So,
Thank you. Any comments or questions from the board?
I have a question.
Mr. Eisner?
Would you be able to let me know what the square footage is of the old house and the square footage of what's proposed?
there's been a sequence. Maybe the Grahams can help me here, but there was a sequence. It was a larger house. Much of it was simply demolished. There's a small structure there currently, which is the dilapidated part we're still talking about, that we're talking about removing. David, do you know roughly the square footage of that? I'm sorry, I have it on a plan here. Do you know the square
Yeah,
footage?
the original structure is about 1,500 square feet. There was an addition built on the house of about 1,500 square feet, which, because the condition was demolished about 2 or 3 years ago by the previous owner.
Do you need to state your name and
I'm
address for
sorry.
the record?
My name is David Graham. I live at 9811 San Sebastian Way, Port Richey, Florida.
And what,
We're
I'm sorry.
purchasing to build. It was originally intended to renovate, and the damage to the structure is too severe and going to be too expensive to renovate as opposed to replace and bring it up to the current codes. In addition, we're trying to keep the same footprint that basically was there before. Because of the slope of the lot, it challenges you for fill, and then you've got runoff issues on the neighbors and stuff, pushing the house to the back of the lot.
what is the square footage of the proposed house?
We're working between 2,500 and 3,000. We're trying to maintain more or less the same footprint as what's existing on the property.
So this is going to be smaller than what was there?
It's going to be close to the same size in terms of square footage, yes.
I had one more question. My question on the where it slopes down to the
Yes.
water.
Yep.
I'm not asking you or telling you what to do. I just was curious.
Okay.
Was it looked into at all, of building possibly a stem wall?
We really haven't discussed that. The slopes at the, I'm trying to think of how best to describe. The house is placed to the northwest of the lot. The lot itself is long in the north-south direction. So it slopes to the southeast of the lot. We have some drawings if you want to pass them and look at them.
I have these,
This is in
yes.
your
Okay.
packet.
Yes, I do.
Well, you can see the depth of the house.
Eddie, can you get on the microphone?
I'm sorry. You can see the depth of the house in this example that we've laid out here. And you can see it's, the depth is not really unreasonable for a typical house. As she said, the north-south dimensions aren't an issue, but the front to back is an issue. The other thing is that we're staying up basically where the existing house is now, which seems very comfortable to the street. But also, the neighbors, I haven't done a survey of their houses, but they're very similar in alignment of using that same setback.
See, why I'm asking this question is because in here it says that this is generally the order of 1,400 square feet to 2,000 square feet in the area. And I'm looking at a house that was, from what you're telling me, 3,000 square feet that also now could be anywhere between 2,500 and 3,000. So my question next would be, is this a normal size for that street?
I think so. Yeah, part of it though too is that we do have the garage that is not counted in the square footages that we're talking about. So we were talking about the air-conditioned spaces.
Mary's house to the north is quite large. Plus you've got the 8 lots across the street, so you have some big
Footprint.
houses.
Okay.
Okay, any further questions?
Yeah, are you familiar with Mary's house that is there on the Kramer Bayou that this is adjacent to? It's a much larger house. And then right across the street, of course, was, the Ellis house, and those houses are huge, relatively speaking. So this is kind of an in-between size.
Okay, any further questions? Anybody? John?
Yes, I will not be voting as I'm an alternate, but I am allowed to ask questions. Correct, Erica?
Yes, that is
Okay.
correct.
On the one plan I'm looking, which is the preliminary outline of the enclosed house with variant setbacks,
Yes.
I can see where the parallel line to the rear of the lot is set at 15 feet, but it looks like on that plan that the pool deck is going to encroach or is planned to encroach far closer than the 15 feet. Is that the current layout?
Well, that's an optional situation. I'm not even sure that we're going to be building the pool, but that will meet whatever the criteria is for the pool structure in a backyard, which is typically not the same as that of the permanent house,
So
the pool deck itself.
So I guess the question then answered is that you're not asking for the pool variance at this point in
No,
time. You're just
no.
looking at the
Right.
actual house. So
Exactly.
the drawing that's proposed is just an idea.
Right. We
Okay.
were
All right. Thank you.
okay.
Further questions? Ms. Turner, anything?
No, sir.
Any comments from the audience? Okay. Are we ready for motion?
Motion to approve?
Second? Anybody?
I'll second.
Any discussion on the motion? Seeing none, let's have a roll call, please, Kim.
Ms. Turner,
Yes, approve.
Mr. Eisner,
Yes.
Mr. Burris,
Yes.
Mr. Abowski,
Yes.
Mr. Chairman Elliott.
Yes. Okay, congratulations. You have, was it 2 years, 1 year? I forget.
2
To build-
years.
2 years to build, to get a permit. Okay.
Better get going. Thank you all very much.
All right, thank you.
Ed, don't forget to take notes tonight.
All right. Next is a variance to increase the maximum total width for a circular driveway. And the address of the house actually is 123 North Florida Avenue. There's some discussion I started maybe, and maybe the staff can start off on this project, please.
All right, thank you. Application to authorize a variance to increase the total width for a circular driveway beyond the maximum allowable width. The applicant owner is Thomas C. and Vassie M. Harris. As mentioned, this is located at 123 North Florida Avenue. A single-family home was constructed on the property pursuant to a duly pulled building permit with a circular driveway that was proposed at a total of 28 feet. There was 20 feet allocated to the north portion of the driveway that corresponds with the garage, and then 8 feet that was allocated to the circular south entrance of the driveway. Upon completion of the home and inspection for certificate of occupancy, the driveway was measured, which is, that is when that takes place, and was found to be a total of 31 feet, with the northern access point measuring 22.9 feet, and the southern access point measuring 8.1 feet. The driveway is constructed of pavers. The review criteria for variance is listed. variances is listed, and if you have any questions on those details, we can answer those. This was duly noticed, and we did not get any public letters from the public or anyone. Staff recommended findings of fact for the record. Number one, the applicant applied for and received a city building permit, number 17-1500, to construct a single-family home with driveway. Number two, the city's final inspection for certificate of occupancy revealed that the built driveway is a total of 31 feet in width, 3 feet wider than the permitted 28 feet, which is the maximum allowable by the Land Development Code. Number three, the requested variance does not arise out of physical characteristics of the property or surrounding area. Number four, the condition on the property for which the variance is requested has resulted from an action by the applicant. Number five, literal enforcement of the driveway width requirement of the Land Development Code would require the applicant to modify the project as it currently exists in order to achieve the permitted layout and comply with the code's required width. Number six, granting of the variance would confer on the applicant special privileges not allowed for other properties in this zoning district in the form of a wider driveway. Number seven, granting of this single variance would not injure or impact the rights of owners of affected properties or create a nuisance or otherwise substantially negatively impact surrounding properties. However, if this type of variance were granted to multiple properties, the neighborhood and public interest would be negatively impacted, and that is expanded upon in the criteria. Staff recommendation, based on the materials submitted by the applicant, the request does not meet all of the review criteria established in the Land Development Code, specifically Section 215.02b. Staff recommends denial of a variance to exceed the maximum allowable width for a driveway. Are there any questions?
Thank you. Applicant, you're entitled to make a statement and cross-examine. But I have a procedural concern that I've mentioned to the staff before the meeting, and at some point, we need to bring this up. Want to do it now or later? What do you think?
Are you addressing staff or myself?
Up to the legal counsel?
As far as what we spoke about earlier, if there's no evidence to that, and you can certainly ask questions about that, my opinion is then it would move forward because the evidence must show that that's been taken care of. If this board wishes to make a motion and not have this heard for concerns of that nature.
Can you speak in the microphone, please? Let me, excuse me for interrupting. The question is that our rules require that the property be posted with a placard in addition to the ad in the newspaper and the notice to the adjacent property owners by mail. And I've been by there several times over the past week or two, and the yellow sign, the placard for the Board of Adjustment hearing is apparently laying on the ground next to the property. And in my experience, when that's happened, the board has postponed the hearing in order to have the property properly posted. But I want to just raise it to the board, and according to our legal counsel, then what is our position?
Well, first of all, while I appreciate that you've driven by the property, what you've just said is not considered testimony. So it's not evidence to whether or not that posting or that was there. So if there is no evidence that supports that placard has fallen, and you can certainly ask any witnesses that you can, then my recommendation would be that we move forward. However, as the board, if that's what you want to do, obviously you're within your right to do it, but my advice would be if there's no evidence to the contrary, we move forward.
All right, let's hear from Mr. Stammes, and then we'll discuss this item.
Okay. Do you want to decide whether we're going to postpone though first, or you want to hear my
Thank
side
you.
of the case?
Any comments from the board about that? Have you noticed? Have anybody been by there?
Yes, I have. I don't see any reason to postpone it, because there are many homes that have similar driveway. I see no reason to postpone it. There's similar driveways all along the eastern section of North Florida Avenue. So even if you put the sign up, nobody's going to object because there's so many of them.
Well, I don't think that's the point. I think the point is that it fell over. Would there be procedural due process afforded to the people of the affected parties in the community? So whether or not they would object, how would they know to object? If you're talking about the neighbors nearby, they should have received a postcard, so.
All right. Any thoughts about this procedural issue from,
I mean, I was by the property not so long ago when it was up, so I'm not sure when it was laying on the ground, but it's been up there the vast majority of the time, and if it got knocked down, it was just recently, I think.
And notices were sent by the city to the surrounding
Yes,
households, and no response?
there were no responses.
I have no issue with it.
Ms. Turner? Any-
Agree, I agree.
All right, so it looks like we're going to continue. Mr. Stammes, please.
Can you make a motion to that effect, please?
Will there be a motion to continue based upon the fact that the property was properly noticed?
Motion to continue.
I second that.
Okay, all in favor?
Can you condition it to a date certain, please?
No, we're not going to continue. We're going to,
No.
the motion is to continue, is to keep
Oh.
on going tonight. I'm
See, when you
sorry.
said motion to continue, I took it as
Yeah,
you
no.
continue like the trial, so.
Yeah, a little confusing. Continue
Okay.
tonight? Is that what the
Right,
motion
so
is?
then there
Okay,
doesn't need to be a
thanks.
motion, I'm sorry. I thought you said
Oh.
a motion to continue like,
Okay.
as in, continue it to a further.
Continue the March.
I apologize.
Wow.
We have a motion to
I'm a
continue
lawyer. When you say
Yeah, I
continue, I
understand.
think
Yeah,
move
all
on
right.
to a different thing.
So,
Okay,
so
we're
the
gonna
answer is
continue
move
here.
forward.
All right, let's go. All right, Mr. Stammes.
Okay. Well, thank you, board members, for allowing us to come and present this. So we had built the home for Father Anastasios and his family, and we originally had permitted the house with a single driveway. It's a 3-car garage home, and it did not have a circular driveway when we originally permitted it, but soon after we started construction, there was a notice by the homeowners that there was a lot of traffic on Florida Avenue at certain times. Specifically, you have 3 schools in the area that let out and begin in the morning and let out in the afternoon. You have a public park that's also on that collector's road there, Florida Avenue. So at times the traffic gets pretty horrendous. In fact, I was taking my granddaughter to school this morning and dropping her off, and there was just traffic platooning by that house in a continuous stream. So there was concern about the danger of backing out onto a collector street. It's a valid concern, that's, there's children on the sidewalk as well, coming to and from school as well. So it's a dangerous situation. So they asked about pursuing a circular driveway. And I want to pass out, if I could, the original drawing that was turned in for the circular driveway that was approved, and from that, I think it'll become evident what the issues were. And by the way, we didn't create the traffic on Florida Avenue, so that wasn't something created by the...
Oh, you can just give it to the board member. Thank you. And just make sure that the board secretary has one for the record. Oh.
I'll just take his at the end. Thank you.
So the original drawing that was turned in attempted to meet the maximum requirement of 28 feet. So the way that the ordinance is written, it's 1/3 of the width of the lot with a maximum of 28 feet. Well, this is a large lot. It's 90, let me give you the exact number. It's 96.38 foot along the road, which 1/3 of that is over 32 feet. However, the ordinance limits the width to 28, and I believe that maybe when the ordinance was written, they didn't really anticipate the idea of 3-car garages at the time. They were thinking more of what you would do with a 2-car garage and a circular driveway, and with that, you would be able to accomplish that in 28 feet.
Excuse me,
That's-
George. Sir, could you please leave the room or turn off your cell phone, please? I'm sorry, George.
That's okay. So when the driveway was constructed, you'll see that there was a sliver of 3 feet that was added to the two-car garage side, so that when you backed out of that garage, you weren't backing across sod and yard, and you could maneuver into that driveway properly instead of having to make a severe maneuver to get into the two-car driveway. So that's where the 3 feet got added by the paver contractor. I guess he was just doing common sense pavers instead of following exactly what the approved plan was. He did maintain the opposite side where the one-car garage is impaired a little bit from getting into, but you can still use it, but it's, you know, again, you're making a tight maneuver.
So we're talking, it's that section between your blue dotted line and the red line.
Yes, and that was already approved.
You need to be on the microphone, George. Take one of the mics. George, take one of the mics and just, you got to be on the record.
Okay, I'll just go back. Yeah, so to answer the question that was asked by the board member, was the area we're talking about is the distance between the blue dotted line to the right and what was the red line. Only the white portion, because the rest of it was already permitted. So it's 73 square feet is what that comes up to be. And it was only not done, you know, in a purposeful attempt to, you know, just blatantly violate the ordinance. It was done to make the driveway usable and also to avoid traffic accidents of backing out onto Florida Avenue. It's a collector street. There's a lot of traffic on it, particularly in that area of it. The other side, the circular side, is 8.1 feet, which is barely enough to keep your tires on the driveway. That lane should, by all rights, be at 10 feet to make a proper circular driveway lane. It starts out at 10 feet and narrows down to 8 feet, and it actually became 8.1 the way they measured it. But again, that's the very minimum size lane you could possibly have to get a full-size vehicle into the driveway. Again, you know, we didn't create the traffic issue on Florida Avenue. That was there, you know, when we built the home, and they're just trying to have a safe way to get in and out of their property. And the fact is it's 1/3 of the width is greater than the 31 feet. So although I know the code says 28, I think that's why we're here for a variance.
Any questions from the board? Okay, Mr. Burris?
I see here that you have 4 lots on this property.
These were 50-foot lots back in the day when they were platted, and there's portions of that make up this lot, portions of the 50s.
Basically, it's close to 25 feet width per lot.
Yes.
So if you take 2 lots of them, you can put a building up, a house up, correct?
In this district, you have to have the 10,000 square foot lot, so I'm not sure if you could make 2 lots out of this, but it's definitely larger than it needs to be to build one home on. You know, in other words, it's larger than 10,000 square feet.
In other words, if you divide this in half, you can put 2 homes there.
I'm not sure that you could get 2 buildable lots on it.
Then you can put 1.5 house.
Well, yes, you could say it that way.
Okay, then in that case.
It's a large lot. It's a very large lot.
We have a 3-car garage. Am I correct to think that each car door requires 10 feet?
That would be correct.
Then we need 30 feet for that, correct?
That would be correct again.
So we only have a foot difference on this whole thing.
Like I said, I don't think the ordinance was created with a 3-car garage in mind. I think when it was created at the time, maybe it was looking at a.
I'm pointing at the contradiction of the ordinance.
Yeah.
The ordinance says 28 feet maximum, and yet you have a 3-car garage.
Right.
Like you can have 10
Right.
feet per door, which is 30 feet. That's what I'm alluding to.
Would not be unusual to have a 30-foot driveway.
So basically, we're looking at 1 foot difference. based on the ordinance that we have on the books. Correct? Am I correct from the city planning, from the staff?
The ordinance doesn't take into account what happens after the width of the driveway is measured at the right-of-way line. Once you get past the right-of-way line onto the property, there are no restrictions on the width of the driveway. So in this case, it widens out, and that's why it can widen out. So I think you're discussing the 3-car garage relative to the width of the driveway. The ordinance is, as far as I know, silent on the width of the driveway on the property. So it only applies to the right-of-way line, so it would have to be 28 feet as it's entering the property at the right-of-way line and could expand out from there.
Okay. Then in that case, since the lot exceeds 93 feet, then 1/3 of 96 or whatever the number is more than the 31 feet that he has there. The applicant, I think, made that distinction.
That's true. The ordinance limits you to 28, but again, we're here for variance because I don't think the variance and really considered the idea of a 3-car garage with a circular driveway. If this lot was 80 feet deeper or 60 feet deeper, you could probably narrow it at the approach and then widen it out and still be able to maneuver in and out of the garages. But, so this is a condition that's specific to this lot, and many of the lots in that area, they're not deep enough to be able to set the house far enough back to be able to do that. So again, that would be something that's specific to the lot, and I think that's one of the conditions of granting a variance.
Thank you.
Could I
Mr.
go?
Eisner? Yes, sir.
I need to go out on a limb here. This is exactly what I brought up last night about a law being changed. But as I say that, I want you to know that we're restricted by our own rules. We are not allowed to change legislation. We are not allowed to make legislation. We have to go by exactly what you're presenting to us versus the ordinances that we have to go by. So on paper, I am very well aware that a double-car garage or driveway should be 20 feet. I'm actually shocked that you made this 8 feet to comply and then changed it to 10. In my own heart, I feel like that is a travesty. Probably if you had flared these in instead of out, you would have been the only ones that do pavers like that, but you would have gone within our ordinance, which I believe needs to change to accommodate people such as yourself. But myself as a board member, and probably all the board members, the problem we have is to decide whether we're going to deal in logic or deal in the ordinance.
Well, I mean, we're here for variance, and the reason that he can't comply with the ordinance are the reasons that we're proposing of why we built the driveway wider than it can be by ordinance. I think the variance process is because we're seeking to deviate from the ordinance. The lot is the depth that it is. We can't change that and didn't create that. It's a 3-car garage house, and in order for it to function properly, it has to be 31 feet minimum. So we're seeking the minimum relief required to allow this to be built. And so I don't see where we're not really meeting the requirements of the variance standards, of what we're applying. You can fit standards any way you want, and there's ways to justify it. You can build a 6,000 square feet of impervious area on a irregular shaped lot, and you can make a argument for why that's a great idea. But does it really fit the criteria? One of the arguments in here was that it was going to create more runoff from the 73 feet of extra impervious area, where we just went and took and I like Eddie Hoffman's designs, and I love it, and I think he's going to do a beautiful job on that house. But you took a lot that has 3,231.83 square feet of impervious area on it now, and you're going to create a house that has 6,489 square feet of impervious area. So if you're really talking about drainage, you need to talk about it consistently amongst all of the times that you apply the variance standards, not just on some and not on the others. So in this case, you have a situation where there's a 3-car garage that's unusable if you really make it constrict down to 28 feet. So you ask for a variance, and that wasn't created by the homeowner, and that's created by the conditions of what we're dealing with here on Florida Avenue, and the fact that the lot's not deep enough to push the house back 20 or 30 more feet to be able to use the driveway. So we're asking for a variance under those circumstances, and I think it's reasonable, and it fits reasonably within the criteria for getting a variance, is my opinion.
I have a question.
Chair, I have a question for the city, if that's all right.
All right, Mr. Hrabowski?
In findings of fact number 7, granting of this single variance would not injure or impact the rights of owners of affected properties or create a nuisance or otherwise substantially negatively impact surrounding properties, period. Then it says, however, if this type of variance were granted to multiple properties, the neighborhood and public interest would be negatively impacted. Can you explain that, please?
Yes, so what we looked at is basically if the standard were allowable for any property on that street, the reasons, and we're talking about ordinances, so we don't want to get into we don't want to sit here and debate the reasons for the driveway width in the code. That's a topic for another day. It is what it is today. Some of the reasons that you have for driveway widths, for limiting driveway widths, are a public benefit based on whatever the standards are. Drainage, roadway, the configuration of the roadway, maintenance of the roadway, and other reasons. So, as Mr. Stamos stated, and we stated in the staff report, one driveway is not going to create a huge runoff problem. We have to look at this as a variance to a criteria for anybody on that street or in that zoning district that would come in for that variance.
Okay.
So we have to look at it that way.
I
If this
understand.
were, so
I understand.
that's why this
I
is
understand
stated.
how you're looking at that. However, if I could ask for a legal opinion, we are not allowed to consider future properties or the public interest in a future way that may be impacted if this were to be granted to multiple properties, because we're only allowed by our code to consider what's on this property tonight.
And that street's built out pretty much. mean, there's
I
no more-
realize that, but we're not even allowed to consider other properties and whether they've gotten variances or not, or in the future. Is that correct?
You are only to consider the application, the evidence before you, and the criteria as it meets with that evidence. Yes.
So we can only think about what's going to happen tonight, and if I go by that, it says granting of this single variance would not injure or impact the rights of owners of affected property. So you would not be creating a nuisance with your driveway, according to this.
And there's really no other lots that I know of on there that have 93 feet of frontage, where a third of that frontage actually is less, or, is more than the driveway we built. So if you're talking about a ratio or proportion of drainage to frontage, I think this one falls probably way under on a ratio to a 50-foot lot with a 28-foot driveway on it, or a 50-foot lot with a 20-foot driveway on it, for that matter. So I don't really see where there's any negative impact at all from this, but there's a positive impact, which is safety for our citizens and for the homeowners.
I have a question. Herb.
Mr. Glanzer?
Yes, this handout that you showed us all with the red line that was held and the moved 3 feet.
Yes.
prior to the red lines being added, this was the footprint that was approved and permitted, correct?
Yes.
And somehow between the time that was approved and the finished product, you're saying that the paver contractor on his own goodwill extended it on his own, or did he ask the homeowner if he should go ahead and add, or did he charge for that? Were there 73 square foot of free bricks that were available?
No, they charged for the square footage of the driveway, but
So they asked the homeowner if they wanted it that
no.
wide?
I think that what happened is he saw the edge of the driveway misaligned with the garage door opening and built it the way that he would normally build a driveway. I mean, that's the normal way you would build it.
So at that point in time, it
As
wasn't,
he's saying, is going against the plans that were submitted and approved with the permit.
Yes.
So,
he
and-
didn't do it per plan.
and so what we're really asking for is forgiveness, not permission because we didn't, when the paver guy saw that it should be widened, we didn't stop at that point and say, should we apply for a variance right now so we wouldn't be here today?
Well, just you have to think about the timing of it. The driveway's the last thing to go in, and then your final survey gets done probably 5 days later and turned in for your CO. So it wasn't like it sat there for 3 months built and we just went in at the last minute with the as-built and said, oh yeah, we knew about it for 3 months. It's the last thing that you do on the outside of the house is driveway, sod, landscape, and irrigation. Probably was there for 5 days or 10 days before it got surveyed. It wasn't a willful and blatant,
Well, I kind of disagree with
disregard.
that.
What's that?
I kind of disagree because you willfully went against the plans that were permitted.
Well, if you willfully
Someone made
do
the
it,
decision.
yeah, the paver guy, made a judgment call in the field that it should line up with a garage door, like the vast majority of them do, and that's how it got built that way.
So are you trying to say that he made an error?
I'm trying to say that we're asking for forgiveness rather than permission is what.
And
we
concur.
had a chance here. We had another one where the concrete was approved by the building inspector and it was actually incorrectly approved. And then the pour was made. This wasn't built yet. And the decision was made to go ahead and widen it on their own volition without checking with
The homeowner.
with perhaps the homeowner, but the homeowner ended up paying for the 73 square feet extra. And, at that, had we been approached with this prior to, it's already built now. Now you're going to take out pavers or leave them.
We're here for an after-the-fact variance. There's no question about that. It happened. Like I said, it wasn't willful. But honestly, in retrospect, the driveway doesn't work, and I think the paver guy realized that when he was building the driveway and built it the way he would normally build a driveway.
If the driveway didn't work, then why was it moved forward in the permitting process as approved? Why would a driveway that wouldn't work be approved and agreed upon by all parties?
I think the draftsman drew up what the maximum was. He held the 8 feet on the one side, and that was what was left on the other side. It was what I'm going to tell you, that probably the way that it got drafted up at 28 feet.
And I don't want to be, trust me, I don't want to be argumentative. I understand the situation. But if you're saying that the safety of the community is affected by that dimension right there, it would appear that, and you're saying backing out into traffic, I think people would use the other side of the driveway. You'd back out of the garage into your driveway and then pull forward and use the 8-foot exit. You wouldn't be trying to back all the way out of that driveway onto Florida Avenue. Isn't that kind of the logic?
Well, if it wasn't circular, you wouldn't have the option, so that's why the circular driveway was requested in the beginning.
Sure. You could have put the full 8 feet on, or the however much right there.
It's got the 8 feet on the one side, and then the other side, well, you can see what it is. If you try and pull in your driveway, you're going to either run over your grass or back out over your grass out of that garage.
You
on
could make
side.
that as wide as you wanted to between the house and the right of way, because the issue is the width of the right of way.
I understand what you're saying, Jackie. Yeah, that's what I'm saying.
There's just not enough distance between the road and the driveway to make a maneuver like that and stay off of your grass. Because it has to cut over, you can't just cut over 90 degrees. You got to transition between the width you come off of the right-of-way at and where you get to the garage door.
That seems to be more than 25 feet, though, from the garage door. It's probably closer to... Which is the right-of-way line? The black line on the sidewalk?
Yeah, the black line.
The heavy black solid line. That's
Yes.
the right-of-way at the sidewalk. And I think the dimension there is 25.34, if I'm looking correctly.
Well,
25, yes, by 25, yes.
25,
within that-
3/4 deep, yeah.
And both sides are flared out with the existing line that was held. They are flared out so that it was designed to be able to flare out into that driveway. I mean, whoever did draft it out did make an allowance for.
Yeah, but
That's
you
all
got,
I'm saying. My only point in my question, and you've answered it, was someone at some time made the determination after permitting that we needed to make this wider, so we did. And at the time of inspection, it was noted that it was too wide, and now you're asking for the variance. Is that accurate?
That's accurate.
Okay. Thank you.
Mr. Burris?
Yes, it was mentioned that the pavers as they sit now are lined up with the two-door garage, the
Yes.
posts of the two-door garage.
Yes.
If it was 3 feet in, the two-door garage, when you back up, you're gonna back up on the grass.
Correct.
No, because we're talking about the area that is from the right of way to the street. We're not talking about from the garage to the right of way.
Yeah, but you've got 25 feet from the garage to the right-of-way line. So at the right-of-way line, if you have to be at 20 and you have to get to 23 by the time, and you got a 20-foot long car, 18, 20-foot long car, you're not going to be able to easily make that maneuver. You will be on the grass. You'll be off the driveway.
It won't line up with the house, it won't look as good.
Well, it won't line up with a house, but even trying to make the maneuver, if it didn't line up and it was built like this, you'd be backing over your lawn.
I understand.
Any further questions from
I
anybody?
don't have any.
My turn. We've had this kind of variance before, several times in the last couple of years, and I've asked, is there any rationale for this driveway width minimum ordinance? And I'm hearing something tonight for the first time that there's some aesthetic value. Is that correct? Yeah, is that what we're saying? I thought it might, is it for aesthetics? Is it for safety? I've seen a number of driveways in this community that have wider than 28 feet, including my own, and several other nice areas in the community, other communities that have very wide driveways. So what's the reason for this ordinance, if you know? Does anybody know?
She can answer the question, but obviously that's not relevant.
Yeah, I'm just curious. It helped to have, for me to know why it is 28 feet.
Being relatively new to the city, I'm not sure why that standard was adopted. I've seen lower standards and higher standards. I've seen lots of communities 24 feet. I've seen communities with apron limits of 30 feet or,
But why would they
the
make it?
width of the apron. So there's all different things on the books. The reason for limiting a driveway width, there are several reasons. I suppose part of it may have to do with the right-of-way and city maintenance of the right-of-way, drainage, aesthetics to some extent, safety and access, those sorts of things. Could be that it was adopted as the minimum that could accommodate, what was thought of for the needs of vehicles as the city saw it at the time. There may be several reasons, and those can be researched. Obviously, we have this standard that we, as staff, have to apply at this time. So
I understand.
Yeah.
But again, like in the past, I've asked this question, it's the width of the driveway is only measured at the right-of-way. So a few pavers could be removed at the right-of-way point and only that point, so that there's only 28 feet instead of 31 feet. Is that correct? And they would be in compliance. It's only measured at the right-of-way line and not any further.
That's how I'm understanding it as well, and because, again, going back to, that is what was approved in the building permit, was for that 28 foot at the right of way.
Next question, for the staff, I believe, or maybe legal counsel. This concerns a contractor's error, and we have a special provision of the code that was brought up last month, I wasn't here, where there are special factors we can consider if it's contractor's error made in good faith. And my question of staff or legal counsel, are we in that position at this time?
the applicant did not present it as a contractor error, and staff did not evaluate it as a contractor error, so
Well, we
we
can
didn't
cons-
apply that section.
All right, but the law allows, this was subsection E.
Yes.
Could
that's
you just
correct.
list, can you, if you get a second, could you please read those criteria?
This is section 215.02E of the variance criteria. It reads, in the highly unusual circumstance where number one, the property owner or contractor has made a mistake in the construction of a structure and it would be economically impracticable to correct the mistake at the time it was discovered. Number two, the appropriate building permit or other use permit had been issued. Number three, such mistake could not have been avoided by the application of normal construction or business practices. And number four, such case is proven before the board by competent substantial evidence. Then and only then may the board grant the minimum variance that will achieve a result that is fair to the applicant and the public alike.
And I would just like to chime in on that. The unusual circumstance does say that it would be, it says the property owner or contractor has made a mistake in the construction of a structure. A driveway is not considered a structure. So I'm not so sure that this section would apply.
Is that correct from staff? Heather, I see you behind. Is that your position? Heather, are you there? You mind? Is the driveway considered a structure for the purposes of this ordinance, subsection E, do you think?
Pat, can you read the section under the definitions for what a structure is?
This is section 241, definitions, number 202. Structure is a combination of materials to form a construction for use, occupancy, or ornamentation, whether installed on, above, or below the surface of land or water.
So this would,
So based on that definition, the driveway is considered a structure. However, has the applicant, Pat, provided relevant evidence that he meets the other criterias of the variance section for contractor error in his application materials?
The applicant has not provided that and has not stated that it was a mistake, which would kind of invoke that section to begin.
So it would be the position of the planning and zoning director that if the information was not provided, then the criteria cannot be applied because they cannot meet that test, and as a result, the staff's recommendation would stand.
thank you.
I would suggest,
Based upon that discussion, any comments?
yeah, I would
Okay,
suggest, because there has been evidence to that point, that if you want to analyze it underneath that criteria where staff has not already done so, you just must make a determination that there is competent, substantial, and relevant evidence that meets all of those criteria.
That was done.
All right,
to
thank you.
use it under that.
All right,
that.
now Father, you wish to make a statement?
For the record, my name is Thomas Harros. I live at 123 North Florida Avenue. People know me as Father Athanasios. And I'm moved to simply make a very quick point. We are within the 1/3. I keep hearing tonight that there is a code which cannot be varied from, yet there's a variance process. The very fact that we have a variance process allows this board to make the variance based on our conversation tonight. So I'm not quite sure why we're saying the code cannot be varied from, because that's why we're here. It's the entire process. The board is given that authority to make the variance, and that's why it's called a variance hearing.
You could run for office.
I don't take this the wrong way, Mr. Chairman, but I work for a higher board at this point.
Don't. So,
But
Very good.
but in genuine sincerity, look, if my wife knew that we were talking 28 instead of 31, she'd rather have 35. Because we're already driving over our lawn because of that 8-foot section on the circle. We're not asking to go above the 1/3. But the truth is, it's a 96-foot frontage. And for a code to say 1/3 and then to further claim but not to exceed 28, I believe there is sufficient give in the ordinance to say, so far as we are in the 1/3, we are not in violation of the code, because the code says 1/3. So I would ask the board's deference to interpret the code at the 1/3 line rather than the 28-foot line, and acknowledge that the driveway meets the code.
thank you, Father.
And I would just like to say, it's not this board's purview to interpret the code, but just to apply the code, the criteria to the code. So while I appreciate that, and more for the record, the board cannot interpret the code in a different way. The board has to apply the code strictly and then apply the criteria to your application to see if it meets that in order to vary from the code.
And just one more point on that, this is not a double lot. While it's a larger lot, the minimum requirement in R100 is 75 feet. 96 does not get you a double lot. So just so we're clear, it's a 75-foot minimum. The lot is at 96.
All right, can we have some questions based upon the subsection E provision of the code, contractor error? Any comments from the board?
And I have a copy of it in case anyone wants to view it while you're asking questions.
Yeah, that'd be great. Let's take a
Well,
look at it.
I have a question.
All right, Mr. Eisner.
Well, I have a statement I would like to say. In the discussion that we've had, what I heard you say was that there was no questioning from the paver company or whoever did that to make it a certain size, he just followed it and he did that extra, and the father didn't ask for it, or anybody didn't ask for that.
Yeah,
correct?
when he built the driveway, he built it to line up with the garage door on that side, and his own judgment that that's how it should be. That's how it got done.
But he didn't ask for any approval or
No.
denial for flaring it or doing anything like that.
No, he did not.
And in going with the highly unusual circumstance, which was just passed to you, sir, it's so talking about the mistake of construction of the structure, so it's our discussion of was this a mistake, economically impractical, but the point that I'm looking at is not to be avoided. Could this have been avoided? I think absolutely it could have been avoided if the contractor had followed the plans which were submitted and approved by the building department.
Well, I think a contractor mistake on its face most of the time has to do with them deviating from the plan. If he followed the plan, it wouldn't be a mistake.
Correct.
You know, that's basically what a construction mistake is. Usually, it's the contractor or the subcontractor not following the plan. That's typically what we categorize as a mistake.
and which this mistake could have been avoided by reading the plans carefully, measuring.
All mistakes can be
Right.
avoided by that. Yeah, that's a fact. I mean, I wish they would all be perfect in how they perform their work, but unfortunately, we don't get that out there in the field, you know, so that mistakes happen.
Any further comments or questions?
Well, let me finish this, please.
Okay.
I mean, it basically just says impractical to correct the mistake at the time it was discovered. When was it discovered?
After completion.
Right. So, I mean, that's pretty much the case in each.
It's pavers. But it's pavers. It's not like we're talking about the gentleman last month who had the really large rebar concrete slab.
Right. It doesn't specify that at all. It just says, would it be impractical to correct the mistake at the time it was discovered? That's pretty much every project that's going to be built. I mean, it's pretty simple math.
Very vague. Very vague.
So every single project, when it's discovered, it's impractical to change it, then, then you fit the criteria. So motion to approve.
I second that.
Wait, no motion yet. We are way far from that. We still have to have public comment.
All right, any further questions of the applicant or the staff by the board? Okay, next, any public comments? Anybody sitting out in the audience that wants to speak on this item? Seeing and hearing none, now I think we're ready for there were no objections, right? Phone or mail or anything, email? No, to this?
Motion to approve.
I second that.
Okay, discussion on the motion?
This is another one of the rules, that ordinance that needs to be changed. This is what I discussed last night, and I will discuss it till I'm blue in the face. Needs to be changed. And that's all I want to say.
Ms. Turner, you wish to make any comments or no?
No, I feel I've made my points and questions. Thank you, sir.
Is there any reason why this cannot be deferred for another month? The next meeting?
Yes, because you have an open motion on the floor.
Yeah, but I'm asking a question.
And I'm
Aside
answering your
from that-
question. There's an open motion on the floor. It cannot be deferred.
All right, well, I'm discussing it. Is there any objection to continuing this for the
There's an
commission?
open motion on the floor. It must be ruled on before any other motions
Point
can
of
be
order?
made. Yes.
Point of order, I believe in Robert's Rules of Order, there is some way where a motion can be retracted, isn't there?
Yes,
not?
but the person who made the motion must withdraw the motion.
Yeah, I'm asking. The structure is already built, and perhaps the city commission may want to address this issue. I don't want to see I don't know how the vote's going to go, but rather than destroy a portion of this driveway, if the city commission, as we mentioned last night, they want these to be,
They want to see that.
they want to be aware of these problems, and this might be an opportunity to bring to the city commission for a change to the code.
It was going to go to the city commission. It would first have to go through planning and zoning. Planning and zoning would then have to hear it. Then it would have to go through a first reading and a second reading, which would take several months. So before that can happen, since the applicant is here, the applicant would have to agree to continue it. Otherwise, you are stepping on his due process
Now,
right.
we're not there yet. I was going to get to that, but if there's, I don't see personally any harm to letting it sit for, we talked about this last month. It's going to take 6 months for a change to the code of ordinances.
And that doesn't guarantee that the Board of Commissioners is even going to
I
have
grant you
listen to
that,
this
but
or even
I-
change the ordinance.
Thank you. I grant you that, but I don't see any harm. But Mr. Burris, what do you think?
Yes, my understanding is that if we write up this case as a memorandum to the commission, take it over to the city manager, he will progress it, the whole thing will progress from there. Aside from the planning board or anything else. I think the consensus
Get on
was,
on the mic.
the consensus was last night to whichever case we have, and apparently this one is one of them, write up a memorandum with the case number and everything and the facts, and give it to the city manager. The city manager will present it to the city commission.
Okay.
That was the direct way of doing this.
First, there was no consensus had last night. It was simply a discussion topic. Second, there was nothing about a specific case in a memorandum going to the city manager. I believe what the city manager said was that if this board thought that there was some code that was disagreed with, that you could bring that to Heather over there, the director of planning and zoning. She could then go ahead and bring that to the city manager, and then the city manager, in his discretion, would bring that to the commission. And the commission, in their discretion, could choose whether or not they wanted to hear it or not. The whole thing is moot if the applicant doesn't want to continue this application. You can, regardless of this application, you can still bring your concerns to Heather and have that moved up the chain.
May I ask a question?
Yes.
Based on the fact that the driveway is already finished and they're currently using it in its active state, any continuance wouldn't further hinder the father.
Well, they could be subject to code
I'm-
enforcement.
But that's what my question was. If it was an active, variance request, would there be any penalties thrust upon that by any sort of continuance? Because right now, it's not hurting anyone.
Well, why don't
to
we
wait.
ask the applicant first? Because if the applicant doesn't want to continue it, it doesn't really make a difference what the board wants to do.
That's a good idea.
Mr. Stamus, would you?
If we
Heather?
go back to that discussion, I have a point of order to provide.
All right, Mr. Stamus, just one simple question.
Yeah, so what would be the purpose of continuing it at this point? Just to do what? For what purpose?
Well, the board might deny the variance request, and then you'd be stuck with having to remove a portion of this driveway. And then maybe the commissioners might change their mind and allow you to have the driveway put back the way it is now.
But the commissioners, that's not their, I don't think that it's their purview to grant variances, right? They would have to change the ordinance.
They would change the code to allow this driveway as is without a variance, or perhaps give us more discretion to grant variances.
And again, that's not guaranteed. I mean, it's up to you what you want to do, but
Well, originally, I honestly wanted to change this ordinance. I talked to the city, the planning department about it because it's not a good ordinance, the way that it's written. But at the same time, I respect my client's time and his money and effort right now to get to this point. And the way that this was granted for us to keep the driveway in place was to go through a variance process within a certain period of time. So here we are. If I say continue it, I guess I could be in jeopardy of them coming tomorrow and say, hey, you didn't get your variance, rip the driveway out by code
I don't think that's
enforcement.
going to happen, George.
Well, I'm just telling
Plus,
you
if
that.
you get cited by code enforcement, you have, well, I don't want to,
This-
Heather is chomping at
you
the bit.
cannot advise him
Yeah,
on what will
I'm sorry.
happen.
Yeah, this ordinance process to revise the ordinance is a lengthy process. Even if everybody's in favor of it, and I think they would be, the ordinance doesn't make any sense the way that it's written in today's world. You're talking probably about a 4-month process or so, I'm going to guess, right? So 4 months. So I was given the opportunity to come here and seek a variance rather than change the ordinance, which I think we need to do anyway. Why don't you grant this variance, and then we'll go change the ordinance? That's what we should do.
Well, you might not get your
Yeah, you just
variance.
need to make a decision
You're
now
allowed
if
to
you wanna
use the
continue.
driveway pending this discussion while it's still.
Okay, so
hanging fr-
here is the piece about that. There is a temporary CO on this process, on this project right now for these folks to utilize their house and their driveway in the configuration that's currently there. That's at the discretion of the building official, okay? At any point in time, they can pull that back and say, send them to code enforcement. So during the time under which we would be possibly amending an ordinance or possibly not amending an ordinance, they're subject to, at any point in time, that provision happening. So a decision either needs to be rendered on whether or not what's going to happen, because outside of this, they could end up in a situation where they do end up in code enforcement board. Now, I'm not saying that that's going to happen. I'm just saying the reality of the situation is it does take 3 months to go through board, given the process that we have in place, because you have 2 other boards that have to see this, plus the technical review team. So George is directly correct. We gave him both of those options and laid that out for him when we discussed the variance coming originally to this board. So he is directly correct in what the information he's provided you tonight on. They chose to go this route because they felt that to alleviate the situation that they have. And again, that doesn't change staff's position on this ordinance. All I'm telling you is just giving you the information on that. We gave them that option. They chose this route, and we support them in making that determination. But I don't think a continuance on the off chance that the board might be moving forward immediately with an ordinance, because I don't have anything right now to say that the ordinance is going tomorrow. I don't have that guarantee. So it may not be 3 months. It may be closer to 4 months. It may be more. And obviously, since we don't have an active ordinance, I can't determine that.
Thank you.
This unknown, we're putting the homeowner in limbo, where the homeowner has made a deliberate, conscious, educated decision to come before us today.
Father, you should make a comment.
Well, I'm a little confused now.
Join the club.
Is there an appeal process to your decision tonight?
Yes, you
Unless
can
you-
appeal to the circuit court.
Not here, the circuit court. All right. I used to dabble in city planning stuff when I was in Boulder, Colorado. And one of the things we used to talk about in planning discussions is when we saw variance after variance after variance, that is in fact what drove the change in code. So by granting me the variance tonight, you're giving the commissioners the evidence that they need that the code is no longer appropriate. Because they're going to be able to say, wait a minute, we've had to grant another variance because the code doesn't make sense for a 96-foot lot. We had to grant another variance because the house, although it's smaller than the house that used to be there that wasn't in compliance, it's still not in compliance. So at what point, if nothing ever gets approved in variance, then the commissioners are going to sit there saying, well, the code is working just fine. There's nothing to worry about. So this board process gives the commissioners the opportunity to say, look, here's another example of why the code has to be changed so we don't have to go through the variance
May
process.
I ask you, sir, to please repeat exactly what you said to the Board of Commissioners at the next meeting? I'm not kidding.
I mean,
Please,
that's
the
what I
both
did.
of you, if
That's
you
what
were-
I did in Boulder, Colorado. I mean,
Oh,
it was a very logical thing.
By all means.
I hate to interrupt you guys, but we need to reel this back in. There is a motion on the table. This is discussion on the motion. The applicant needs to make a decision whether or not you want to continue your application or not.
Yes, I do.
You want to continue it. Then we need someone, if someone wants to, whoever made the motion can revoke the motion.
So I just want to explain to you, sir, since there was confusion. Last night at the Board
No,
of
we are not
Commissioner
discussing
meeting.
that. There's a motion on the table right
Last night
now.
at the Board of
Allowing this
Commissioners
man to
meeting.
speak.
At the last night at the board, they told us to do exactly what the chairman just did, to ask that we could just send these people with their projects to the commission, because they're saying that we're giving away too many variances, and they don't like that. And they think that we need to go through a different process, which is to do what the chairman just asked, so that we could send each one to them so they can change the law.
Okay.
And that's why I'm saying, please
If that's what they want, let's do it.
do it. But then we can also move forward with the motion. I made the motion to approve.
Wait,
We have a
there's
second?
a first and a second.
So,
Mr. Vice
If that's what the
Chairman
commissioners
Hrabowski.
want, let's do it.
yes, thank you.
So Vice Chairman Hrabowski, if you'd like to withdraw your motion, you can certainly do that. Or if you don't want to withdraw it, then it needs to be voted on. Those are your two options. And there's no, if you're going to have discussion, it needs to be made into the microphone on the record,
Sir?
please.
So you'd be okay if we did continue it and just wait? Or you want your variance tonight?
Are bulldozers going to show up to dig up my driveway?
We don't know that.
No,
I
that's not
cannot,
how
I
it
don't
works.
believe so, but I cannot say with any certainty. We have a,
All you need is to change the concrete saw to cut 2 inches by 3.
Let's move.
so what, it's up to you guys, whatever you want to, I mean, I've got the motion to approve. So if you want to do it tonight, we'll do it tonight, but I'd also like you to please approach the commissioners.
I have no problems approaching the commissioners on this topic if it helps, but I'd rather put to bed the question tonight if we can.
Okay, then we move forward tonight.
All right, so we got, Ms. Yothers? Oh, you're raising, you want to make
Glad
a
I'm an
comment?
alternate.
All right, we have a motion and a second to approve the variance. Any further discussion?
Yes, I have one more thing. Where were you last night?
Any are relevant
I
to
was at
this?
a prayer service for a young man who died of an overdose drug.
I'm sorry.
All right, all right, any, I guess we're ready for a roll call, please, Ms. Yothers?
Ms. Turner,
Deny.
So
Mr.
no on the motion.
No.
Mr. Eisner,
Yes.
Mr. Burris,
Yes.
Mr. Belsky,
Yes.
Mr. Elliott.
I know you already have 3 votes, but I'm going to vote yes on because of the subsection E, the contractor error. I think you satisfied the burden of proof there. Otherwise, I would have to say no and go to the city commission for some relief on the code.
We're going to go anyway, I think.
Thank you very much.
All right, thank you.
Your time.
Any further comment on that item, Ben?
Well, please, again, please, both of you, talk to the mayor, especially, and at least 2 commissioners.
Thank you all for enduring that, and appreciate the granting of the
Okay, thank you
variance.
for your patience in the audience. The next item then is number 4, application 17-125, variance to reduce the required distance between a water's edge and a pool screen enclosure on Village Drive in the Westwind subdivision. Staff, please.
Okay, I'm Michelle Wagner. I'm with Planning and Zoning in the city. Application 17-125 requests relief from the literal enforcement of Land Development Code 36.02, requiring 36 inches of clearance between the water's edge of a swimming pool and the swimming pool screen enclosure. A 5-foot drainage easement runs the length of the rear property line between the retention pond and the concrete deck surrounding the swimming pool. No structure may be built within that easement. The applicant hired licensed contractors to perform permitted work. They did not request, nor were they aware of, any potential nonconformity with the City of Tarpon Springs Land Development Code. Literal enforcement of 36.02 would have the effect of denying the applicant reasonable use of the property. Granting the variance in this unusual circumstance would not confer any special privilege to the applicant, and granting the variance has no impact on other properties. Public correspondence. Notices were sent to property owners within 200 feet of the subject property. A legal notice was published in the Tampa Bay Times, and the property was posted. No comments were received. Findings of fact for the record. The request is to reduce the required 3-foot distance between water's edge of a pool and a screen enclosure from 36 inches to 29 inches. It would be economically impracticable to correct the contractor's mistake. Further, economic impracticability notwithstanding, it would be impossible to build a new screen enclosure in compliance with this subsection due to site constraints beyond the applicant's control. The granting of the variance would not extend any special privilege to the applicant. The granting of this variance would not hinder the character of the existing neighborhood, and it would not create a nuisance. The request conforms to the general intent of the Land Development Code and the policies of the comprehensive plan. Staff recommends approval of the requested variance to reduce the required distance between the water's edge of a swimming pool and the pool screen enclosure from 36 inches to 29 inches as the minimum variance that will achieve a result that is fair to the applicant and the public alike. The request meets the review criteria established in Land Development Code Section 215.02B and Land Development Code 215.02 subsection E of the LDC.
Thank you very much. Is the applicant in the audience? Yes, sir. Have you been sworn? All right, would you please accept the oath from our legal counsel?
When you approach the podium, if you could just please raise your right hand to be sworn in. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? So sworn.
All right, please state your name and your address, sir.
My name is Lou Piccinino. I live at 514 Village Drive, Tarpon Springs.
All right, please proceed to state your case. What's your reason for the variance?
Excuse me?
Please state your reason why you would like this variance.
Oh. Basically, I like to use my pool, and it turned out that I thought I passed all the inspections. I thought everybody did everything right. I paid for everything. And then I realized that one post, which is a big post, is only 29 inches from the water instead of 36. The rest of the decking is far exceeds 36 inches. So I'm here asking for relief. I can't extend the deck because of the easement, and it would be really super costly to move everything.
Okay, thank you. Have there been any objections from anybody?
No.
Michelle? No comments, nothing?
No.
All right. Any questions from the board?
I guess you discovered this yourself, right?
No, I discovered it when the inspector came with his tape measure and said, wait a minute, we have a problem.
Okay.
I mean, it's a huge deck, but it's,
Right. It's about 6-7 inches
Yeah.
on the one post. Gotcha. Thank you.
Okay, any comments from the public? Any further questions from the board or the applicant, staff? Ready for a motion?
Motion to approve.
Second.
Any discussion? Roll call vote, please, Kim.
Mr. Glenn, Ms. Turner,
Approve, yes.
Mr. Eisner,
Yes.
Mr. Burris,
Yes.
Mr. Obowski,
Yes.
Chairman Elliott.
Yes. Thank you, sir.
thank you. I'd just like to say one thing. In my younger days, I served as a chairman of the Board of Adjustment, and I know how hard it is to make decisions. It's my first time I've ever been in front of one. And I always thought I did a good job serving the public. And I just want you to know, I'm a new permanent resident to Florida, welcomed by Hurricane Irma and the 29-inch problem, that the staff and the government of Tarpon Springs has treated me beyond expectations. And I want you to know that. I would like you to know that. And they are just very, very, very good. I thought I was good, but the way Tarpon Springs works made me look like an amateur. I thank you for your help tonight.
1 second.
Yes.
Could you also meet with the mayor?
I will write, and I have written in the past, because I don't think enough citizens say what's right. And that's been a problem that I lived with when I was on boards. But I will do that. I will absolutely do that when I go home tonight. I'll email them if that's okay.
Where are you from?
Originally from New Jersey. I started coming to Tarpon Springs in 1981. It just took us a long time and a bout with cancer to say, let's make it permanent and stay in Tarpon Springs. So I've known Tarpon Springs since 1981. My father-in-law would come.
All right, thank you, sir.
Thank you.
Thank you for your kind comments, and we endorse that too. We respect our staff tremendously. They do a very fine job. All right. Yeah, all right. I've had it more than 2 days, and I don't know either. All right, the next one, a waiver. This is not a variance, it's a waiver of this requirement for a sidewalk construction on Athenian Way in Tarpon Springs. This is just off the Safford Avenue, Live Oak Street property near the river. Staff, please.
This is an application to authorize a waiver of the requirement to construct sidewalks for 14 properties within the Anclote River Crossing subdivision. And probably best, if you want to refer to page 7 of the staff report, it has an aerial photograph that shows the development. Might help while I'm explaining this situation. This is a 36-unit development. 26 of the units were built in 2007, and the remaining 10 were built in 2017. The development roadway, Athenian Way, circles through the development almost in a circular motion. Inside, within Athenian Way, in the interior, are 22 units that were built in 2007. The required sidewalk that was on the approved site plan for the plat was built around an entire interior perimeter of Athenian Way. It also, the connections to the east via Live Oak, the eastern neighborhood, and also to the west over to North Pinellas Drive were also built. The subject of tonight's waiver request is the 14 units on the north side of Athenian Way, as you can see in the aerial. Those had a site plan approved with a sidewalk in front of them, connecting the 14 units to each other and not to anything else. The right-of-way in this development is privately owned under the control of a homeowners association. It's very, I'll say, intimate and close physical setting. What we have is a 40-foot right-of-way that has a roadway with 10-foot travel lanes, curb and gutter drainage, utility easement where the sidewalk would go. The units on the north side of Athenian Way are very close to the road. The driveway depths are on the order of 8 feet. And a lot of times, if the cars are not in the garage, depending on what they are, if they're not a compact car, they do occupy that easement a lot of the time. And we do have a sidewalk on the south side, uninterrupted by drives, that goes the length of that interior perimeter of Athenian Way. The driveways are close enough together where the aprons touch some of the time, so we have a lot of paving there. So in short, this is an area where traffic is calmed by the loop and the lane configuration of Athenian Way. And the existing sidewalk is very close to the 14 units. The other item I might mention is there is a sidewalk that was designed to connect those 14 units to each other in the back on the water side. That was installed, and that leads out to the road as well. The variance criteria, there's a lot of detail given here in the variance criteria. We can answer any questions with respect to that. Waiver criteria. And this is the sidewalk waiver criteria in section 132 of the code. The waiver request was properly noticed, and we received one letter in support of the waiver. It's in your packet. Staff recommended findings of fact for the record. Number 1, Anclote River Crossings was originally platted in 2004, and 26 of the units were built in 2007, 4 of which were built without the planned sidewalk that was included on the plat. The property underwent a partial replat in 2016 for the remaining 10 lots, which were subsequently built in 2017 without the planned sidewalk. Therefore, Lot 23 through Lot 36, the 14 lots, were built without the platted sidewalk connections along the north side of Athenian Way. Number 2, the physical and environmental conditions on the north side of Athenian Way in the subject area are such that installation of a functional sidewalk would not be practical due to the configuration of the driveways, potential for increased pavement, lack of connectivity to the rest of the development and the surrounding area, the nature of traffic calming on the street segment, and the presence of a functional, uninterrupted, and connected sidewalk on the south side of the street in very close proximity to the subject properties. Number 3, the need for the waiver arises from the physical shape and conditions of the existing right-of-way, as it is not sufficient to allow for installation of a properly functioning sidewalk, and additional right-of-way is not required for this plat. Number 4, the conditions of the property were not self-created and did not result from an action by the applicant, since it is still physically possible to install the sidewalk connection should the waiver be denied. And one point, just based on earlier questions as far as when this was discovered, the 4 units built in 2007 on the north side of Athenian Way don't have a sidewalk. Staff has researched extensively, and we don't know what happened there. So we don't know why it was, why it's existing without a sidewalk. The 10 units that were built in 2017 turned in as-built plans without the sidewalk, and that's when this condition was discovered.
Thank you. Is the applicant here? Anybody? Sir, would you? All right, gentlemen, would you come first, and then after that, please? Okay. Yes, sir. Sorry.
My name is Philip Burke. I live at 107 Athenian Way, Tarpon Springs. I am a member of the Board of Directors for the Anclote River Crossing Housing Association. The Board of the Anclote Crossing Housing Association support the city in reference to application 17/128 waiver of requirement for sidewalk construction for the following reasons. The sidewalk not being constructed over a decade ago was an oversight by the city and the original developer. The developer has long since disappeared and is no longer affiliated to our community. Requiring a sidewalk along units 101 to 127 would pose undue financial burden on our association, which has struggled to recover from the housing and financial crisis in the past decade. Anclote River Crossing has a sidewalk located directly across the street, only 23 feet from 107 to 127, and spanning the entire community and including the exits. Requiring a new sidewalk would replace mature landscape and more concrete pavement, hereby compromising our curb appeal and creating more runoff into our neighbouring waterways. The street in front of our units, 101 to 127, is a private street and having no through traffic and very low traffic count. The added sidewalk would not lend to public safety or function for the 14 residents along that limited stretch of the street. There has been no pedestrian incidents in the past decade warranting concern for additional sidewalk. I therefore ask the Board of Adjustments on behalf of the Anclote River Association waiver of the requirement for sidewalk construction.
Thank you, sir. And thank you for using the American English sidewalk instead of pavement, which we appreciate. Anybody else in the audience? Any questions from the board?
I just have a regular question for either staff or Erica. What really is the
John,
difference?
could you on the mic?
Oh, I'm sorry. What is the actual difference that we should consider between a variance and a waiver?
The criteria is different.
Okay, but is there anything longer lasting? I mean, you've mentioned before that a variance travels with the property. Does a waiver also travel?
I mean, the waiver is just a waiver from a requirement of the code. So it functions similarly to a variance, but it doesn't require the same criteria that the variance requires.
Okay.
So it's a waiver from the provisions of the code.
Just checking for any future. Thank you.
And similar question for you. If this waiver were to be granted, does that ensure that the homeowners association is protected for future action of, my fear is we grant this waiver and then 10 years from now, somehow someone comes back to them and say, you were supposed to have these sidewalks. I mean, does this thing have staying power?
Yeah, I mean, they're granted a waiver from the provision, so yes. Now, in the event that, say, they sold the property, demolished it, and it were to be constructed again, that, depending upon what that looked like, the conditions may not apply for the waiver. So maybe in that sense, the variance doesn't necessarily run with the land, but that would be the same as any other variance. I mean, if you're demolishing a building and
Like if they
building
all
something
sold
brand
off
new.
these 14 units,
Right.
built one big, huge house, then that's a whole other thing. Okay.
And if we deny this waiver, since they're claiming that it's an oversight by the city and the original developer, would the city be open to some sort of litigation for denying the waiver?
Well, the city's always open to some sort of litigation. But I understanding what you say, yeah, they can, I mean, certainly they can take an appeal to the circuit court. Well, that's a good question. Let me real quick look at the code, because the sidewalk provision says that this is a determination made by the Board of Adjustment. But you do have a provision. Yeah, I mean, you do have a provision for appeals in your code for hearing and deciding appeals. And that's from an administrative decision.
While she's looking that up, is it fair to ask a question about if all 14 current residents are in favor of it?
Actually, some of their homes are unoccupied. It's the 10 units been built in the last year. 4 of them are sold, and we've not really had opportunity to meet them as a housing association. The 4 units that were built in 2007 were all in favour, and the board of directors are in favour of this waiver.
Staff also did obtain an owner affidavit from David Weekly Homes. I believe there's a representative here if you need to hear from him. Those that owns the remaining unsold units.
And to answer your question, yes, there is an appellate procedure. It's the same as every other appellate procedure. If you deny the waiver, they can go to the circuit court for an appeal.
So you already have a fantastic sidewalk that's working well, connecting point A to point B as it should be, and this would just be a sidewalk connecting 14 people that are already connected on the other side.
You're absolutely right. The sidewalk works onto the south side. If the sidewalk was constructed, it would run to the west of our boundary and stop. There isn't room on the west side to continue it, so you'd have to cross to this other sidewalk to further the journey.
Mm-hmm.
So to put a sidewalk in now, it would be...
It's going to take you nowhere.
Mm-hmm.
Any further comments from the audience? You wish to make a comment, sir? Okay. Okay, thank you. Further questions from the board? The developers of this property were English, and if you knew that.
They were,
Two
yeah.
English brothers.
I knew them very
Yeah.
well.
We
They went
did,
bankrupt.
Yeah. Okay, ready for a motion? Do we have a motion?
I'm sorry, I might have missed it. Did we ask for public comment?
I did, yes. Any further, is there a motion from the board
I make a motion
to approve?
to approve.
I'll second.
Motion is second, discussion. I've been out to the property to take a view, and I think one sidewalk is enough. And I'm much in favor of sidewalks, but I think one is sufficient. The code used to state, I don't know if it still does, and that's what I'm asking the staff, for the sidewalk waiver, if it's unreasonable or unwarranted, instead of the usual hardship, quote, hardship requirements, if a sidewalk is unreasonable or unwarranted. I think that's still the code. And I think in this case, it is unreasonable and unwarranted.
So you're saying that the code doesn't need to be changed in this regard?
No, in fact, I wrote it many years ago. It says, sidewalks may be waived if a sidewalk is unreasonable or unwarranted. It's a lot easier burden of proof than the variance requirement. Often it's not a hardship, but you just don't need a sidewalk. Okay, we ready then? Roll call, please, Kim.
Ms. Turner,
Approve.
Mr. Eisner,
Approve.
Mr. Burris,
Yes.
Mr. Obowski,
Yes.
Mr. Elliott.
Yes. Thank you, whoever is the applicant. Congratulations.
very much.
Okay, thank you, sir.
Thank you, sir.
Thank you for your patience. All right, let's go back to our minutes, please, of December 27th.
I read through and you're going to ask for a motion? Or do you want to discuss
Any
it?
discussion?
Only that on the, I guess it was a previous meeting, I believe we discussed moving it, the minutes, the approval of minutes permanently to the end of the meeting. But as you mentioned at the beginning of this meeting, we may need the Board of Commissioners to approve that. So does
You
anyone
don't need
know?
the Board of Commissioners to approve that. You can change your rules of procedure to reflect that.
You said we could not change our rules without the Board of Commissioners' approval.
I have never said you can't change your rules of procedure without the Board of Commissioners approval. Your rules of procedure are set by yourselves and done by a resolution. So you can change your rules of procedure, these rules of procedure. You cannot change your powers and duties that are listed in the code.
Oh, well, that's different from what we were told
And
in the past.
It's not, and you can look at the recordings and see, because if you recall, there was discussion on an agenda item for changing your rules of procedure as it was discussed for orders, and then that never actually got changed. So you guys have had discussions on this board with changing your rules of
Oh,
procedure
so we
in the
can
past.
change the rule on orders as well.
No. I did not say that. I said there is a specific provision about orders, and you were talking about changing that, and you didn't. Now, there is a provision in your code, in the code that you cannot change, that goes to orders. But the provision in your rules of procedure that governs orders, you talked about changing.
Does it need a motion and a vote?
Well, you can't change your rules of procedure now. That's something
Yeah.
that has to be noticed on the agenda.
But
And that's been done in the past.
In our rules of procedure, it says the minutes are in the beginning. We can change that, you're saying?
Yeah, you can change your rules of procedure, where it says conduct of meetings, you can change that. You can change your rules of procedure.
And also, the provision about orders is also in our rules of procedure, I believe.
I believe there is a provision in your rules of procedure with regard to orders, but also keep in mind, and I think it's in number 14, I might be correct, maybe not.
Yes.
But there is also a provision in the code of ordinances governing
Oh.
the orders that you cannot change.
Oh.
But in your rules of procedure, as long as it doesn't conflict with obviously the code of ordinances, you can
All right.
change your rules of
All
procedure.
right, thank you. I'll look in the code to see about that. So anyway, comments about the minutes themselves?
Well, I just want to be clear. So you're saying we can change the rules of procedure, but then you said it had to be noticed. So we did not notice this changing of the approval of minutes to the end of the meeting. We just did it. So do we need to redo that?
No, it's an administrative function. I don't see that there's any harm to anyone, any members of the public. It was noticed to put at the end. So at this point, no.
All right, so are we back to discussion of the minutes themselves? I was not present, so Mr. Hrabowski, you want to take over on this?
Okay, do we have a motion?
I'll do a motion to approve.
I second the motion.
And roll call.
Ms. Turner,
Approve.
Mr. Eisner,
Yep.
Mr. Burris,
Yes.
Mr. Obowski,
Yes.
Mr. Elliott.
Yes. Okay, thank you. Next, I see we have election of officers, chairman and vice chairman.
Can I call for any nominations for chairman of the board?
I nominate Mr. Elliott for
I
chair.
second that.
Are there any other nominations for chairman of the board? Hearing none. All in favor of Mr. Elliott for chairman of the board, say aye.
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 Opposed?
Thank you for your support. The next vice chairman.
Any nominations for vice chair of the board?
I nominate Mr. Chris Kabowski.
I will second that.
All right, any other nominations for vice chair? Hearing none. All those in favor say aye.
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 Any opposed? Congratulations, gentlemen.
Thank you. All right, then we get to staff comments.
We have none. Thank you.
Board comment. I want to commend the staff for their excellent report this month. I think that the analysis of the items are very well done, and appreciate their efforts. Thank you.
I would just like to comment on what we attempted to do earlier, and I think that we can do that in the future if we get some case in front of us that fits that criteria, and perhaps we can send them to the commission. But hopefully that won't have to happen, because hopefully those two gentlemen will approach the mayor and commissioners and make that change.
Do we do that by motion? If we want to make a recommendation to the city commission, as they said, I believe last night, what do
No.
we do?
No, you can, in board comments right now, or individually, you can go to Heather, and you can tell her what the code provision is, the section. I would suggest that you have the actual section number you can send to her, but I'll let her determine what that looks like. You go to Heather, you give her the information, tell her what needs to be changed, and then she will move it up the line.
Thanks for the
Can we do that in the meeting? During the discussion, we can make a comment about that?
Yeah, you can certainly make it in the comment, in board comments, or you can shoot her an email, or, you can go into her office. But if you're going to do it as a board, again, this is a sticky wicket, because your powers and duties don't actually allow you to do this, but the Board of Commissioners has said that, go ahead. So in this situation, I would say, to keep it in the public, sure, let's go ahead and make it under board comments. It'll just be kind of informal, but just need to let Heather know, and then she'll take it from there.
If the board's of a mind to make recommendations to specific code sections, can we do it now?
Yeah, I mean, go ahead. And again, there's no rhyme or reason. There's no rules for this, because you're technically not allowed to do it. So I don't think you don't need to make a motion. You don't have to have a consensus. You just say, hey, Heather, section 217.01A, we disagree with this. See what you can
Want
do.
to bring it up now?
I don't
or
even
no?
know what that section
No?
is. Just the
Please.
disclaimer. I have no idea what that section of the
All right.
policy is.
All right, we're now open for discussion about specific changes to the code. I don't want to take too long. Let's think about it for a month, but we're open now, Mr. Kabowski. You're on. You have the floor.
But we already submitted our letter, so that's what I'm talking about, those
Well,
changes.
That's not the land develop. Well, I guess that is the land development code. Yeah, you're talking about the criteria that you're to consider for.
Yes.
Okay, well, that's already been taken care of. That's not what the commission asked for recommendations for. They asked for recommendations in the event that, like the driveway thing, that you get a lot of those coming to the board. So that would be something they would want to recommend.
Well, I mean, I personally think that, these are detailed things that we are referencing, application numbers and dates and addresses, to where it would benefit us to be able to give an educated, comprehensive submission to staff. So if we could, as suggested, email those things as individuals. I can't come up off the top of my head, off the fly, with names, addresses, numbers, exact things that I want to submit right now. I would benefit from going home and doing my homework and emailing Heather. That's just me personally.
And you know what? Maybe this needs to go to the city manager for exactly what the form is that he wants, because my understanding in discussions was that he just wanted an informal recommendation that would go through Heather that says, we get a lot of variances with regards to swimming pools and the rear setback,
right?
With the 36 inches. we think this needs to be changed, that's outdated. We think 3 feet's ridiculous. We want it to be more.
Ms. Erwiller, I see you wanted to speak.
Names and addresses and specific applications are not necessary.
Okay.
What
Thank
the
you.
board was trying to say is if you have a problem with the law, a specific section of the code, like Erica is talking about, the pool thing,
Right.
the fence thing, all the other issues that you have dealt with in the past, and some of you are still new to the board, I recognize that. If you have problems with those individual sections of code, that's what they're looking for you to bring to me so that I can take it to Mark, so that then Mark can move it to the
Thank you
board,
for that
and then it can go through the provisions. Mr. Hrabowski, if you still want to send those sections for the variance section, we can send it up to the city manager again. I just don't know that you're going to get anything beyond what was discussed last night. I think that has been discussed by the board. However, if you want to move that same information that came out of your letter that we responded to, that's fine. We can move that forward up there. I just need to know that if that's your discretion, that's at this board's discretion. You just need to let me know. I'd be glad to provide that once again to the city manager.
I think that was discussed enough last night. We made our point. I could have done a little more articulately. I got a little bit, I was surprised that we were not the first ones to speak on this item. This was our item, and everybody else talked about it ahead of us before we had a chance to say anything. And but that's the way it is. Is anybody willing to make a motion now to?
You don't need to make a motion.
All right, anybody, let's go down the line, start with Mr. Glenzer. If you can think of anything now that you would like the commission to take, or the city manager to take a specific look at.
Well, it would be
as
the
far
planning
as-
director.
It would be the planning director, but it will go to the city manager.
All right.
Yeah, just, I think you touched on two of them that I think in my short term, we've run into a few times, and I don't know what the right answer is, but the pool enclosures, the driveways, and then I would submit that, Heather, you even mentioned that the parking spaces might be outdated.
Yeah, parking schedule, but I get where you're going.
Yeah.
Mr. Burris?
I agree with that, but should we wait and collect a number of them and then send them in?
I would say do it as they come.
Okay,
Let's
then
have
we
it.
Comes to your
one
mind, we
tonight.
have Heather's email.
This would be
Shoot-
an
shoot
appropriate
it to her.
time each meeting, and we could.
Right,
just-
because again, and I don't want to beat a dead horse, so this is the last time I'm going to say this. Because again, the board that's actually, I promise. Well, I'm not making that promise. I take it back. I retract that. The board that actually is responsible for making changes to the land development code is the planning and zoning board. So they actually, within their powers and duties, have a specific provision that says that they are to review the land development code and recommend changes to the Board of Commissioners. So you guys are giving a special provision. I don't know how long that's going to last, so this may be temporary. So my suggestion would be, take it as you can get them to Heather as soon as you can, because at the end of the day, they're still going to have to go through the planning and zoning board to get to the commission at any rate. So, because that is the city's local planning agency that is deemed by the Florida
It's
statute.
understood, yeah.
All right, so.
Do them as they
let's-
come.
all right,
So,
Mr.
yeah, so then I would recommend, Heather, that we address it the way the gentleman spoke about how they did in Colorado. If we could just go through the variances that we have given and see which ones are identical or similar, and say, why are we having to give these so often? Why don't we change that rule? Perhaps let's do it that way. That solves the problem. It's just simple math. We just look at what has been done and say, okay, this is obviously a problem. Let's change this. That seems to me better than just having, I mean, we can still continue to do it the way we're doing it, but that solves it all because we have the history. We know what variances we've given, and we know why we've had to keep giving them. So let's go through the history, look at those, and then present those to the people that need to have that information,
Then I would
and then they
suggest
can make
that-
the change.
I would suggest that one of you do that, because staff is not going to be doing any of that.
We'll do it individually. Both for you.
Well, like, for example, I wasn't very smooth last night. I apologize, but for my tenure, I did go through, and there were 15 cases, or 11 cases, I'm sorry, from May through December, and I would have imagined that the ordinances for a variance, as per what a variance should be, if the city attorney's office was thinking it should be 1 out of 100, 9 out of 11 were actually staff recommendations. And I understand that.
That doesn't mean that they
That
were
doesn't
supposed to be
mean that-
granted a variance.
I understand that, but the staff is also supposed to analyze things and give their recommendation based on
The
what
information
does
they
fit.
have.
Right. And to my point there, I would say that I wouldn't see anybody here arguing against the staff recommendation from the public. But I understand it's a loophole there, but you get my point. If the staff has done their research and they think it should be a variance, then if there's 11 of those and 9 of those were staff recommended, perhaps those were.
Well, for purposes of this discussion, though, because of what the mechanism that was discussed last night, if there are you've already listed 3 sections of the code: the swimming pool, land development code, the swimming pool setback issue, the 3-foot surrounding issue, the
Driveway.
the driveway issue, and then the parking issue. So there's 3 right there. Are there any others that you guys can think of right
Well,
now?
wait a minute. First of all, I don't recognize your authority to say the city staff will not be doing that. First of all, who told you could say that and that would mean anything? Second of all, if Colorado city planners and staff could look at common sense stuff like that and their history and notice that there was a problem, maybe we should change the law, then why can't we do that? So
Okay,
that doesn't
I'll tell
make
you
much
what.
sense. Now, I'm not trying to throw more work on you, Heather. I thought that would make it easier than us
Respectfully.
lobbing all this stuff at you, and then it just doesn't make sense. So if you have the history and you could look at it, I thought maybe you would be the one that could discern that. I'm not trying to make it harder on you. I was trying to make it easier.
Respectfully, we are not Colorado. We are in Florida. It's a separate jurisdiction. There are separate sets of laws. So while I appreciate that.
So does that give you more jurisdiction to say that you can tell to me what the city staff will do or won't do?
Not about jurisdiction.
Then what is it?
It's about having conversations and telling staff that, one, you do not have, if you want me to take a hard line stance, I will continue to do that. I'm trying to work with the board. I don't
Not about a
represent-
hard line stance. You told me that the
Let me
city will
finish
not do
speaking.
something. How are you speaking for the city?
Let's defer to the chair because I would like to finish speaking, but this is obviously not a productive conversation.
Well, let's get back to the main item. Does anybody on my right have any specific items of the code other than the 3 that were mentioned that they want Heather to look at that you can recall right now? We can do this again each month.
We discussed, which was pretty, not well done, was the 2-foot between an attached garage, between a attached garage and a house. I know we only had that once.
That was just because it's an expansion of a non-conforming structure. That was a rather unique situation. I don't think that's going to come up, my personal opinion. Just you can't expand a non-conforming structure
Without
a
you.
variance.
Without you guys. I mean,
And so we
that's
got
how,
the variance.
that's what that regulation says. And I can tell you right now, non-conformities, there's a lot of case law there. We have I would say we have a very good section on that specifically because you are really holding people to the criteria that you have there. I mean, it's a very tight criteria. And then this board is the relief valve in that criteria. I think of all the issues that you guys have dealt with, the non-conforming use section is probably the best written section given the issues that you have to deal with. You know, the thing that comes on a regular basis is the non-conforming lot thing. You know, we do have that section under the non-conforming lots, but again, if you put a group of non-conforming lots together, it now becomes a conforming piece of property. And basically your standards say when you can create a conforming piece of property, that is the preference of the commission, essentially. So I think that section, I would agree, was probably well written, but it's certainly something we can add to that list if you want to look at it.
All right, Jackie, you have any specific items now? You can always come later. But
I mean, like I said, it's, gun to your head, thinking through my notes. I'm a very visual person. I like to go back and look through my notes. I do agree with what was brought before. I would like the opportunity to review those things and email Heather concise bullet 2-3 points. One thing that I can think of, and I don't know if this is appropriate or where this fits in with this, is I feel like I'm starting to see a trend of things coming before us that are a result of either an error within our city inspectors, our the building permitting departments, to where one says, yes, you can do it, and then it comes out to be inspected, and the inspector says no, where I'm seeing some conflicting information that's happening internally. And like I said, I've had this conversation with Heather and the staff before. I understand. I'll be the first to say, we're human. Mistakes are going to happen. And I know that you work with folks through those situations, and I greatly appreciate that. But like the gentleman last month with his slab. So, in thinking more about it, thinking inspector didn't measure it day one, comes back the next time and measures. So, and the homeowner measured, bless his heart. Yeah, the homeowner measured and busted his own self. So, but who is penalized and who's brought before us for it? The homeowner. So some of those things, and I just don't know where that may be. And like I said, again, I'm a word person. I want to sit down and craft my statement.
I think that's going to fall to more of a procedural thing through the building department.
Okay.
So I don't think that's something that can be remedied through the land development code.
Right. That
if
can't
you
be.
can
That's
think
not
And some of the
necessarily-
contractor piece is not is part of the issue, has to do with licensing in the county and the lack thereof, the oversight and things that have happened. So as a result, understand that while the property owners are the ones that are coming to you, they can't necessarily just go to court very easily and get a remedy.
Yeah, and I feel bad for him.
And so this is their relief valve. And I mean, we've even had issues, some of the variances you've seen tonight, with folks who actually take ownership. I mean, George took ownership of that situation and then brought the remedy here. I mean, he brought the owner with him.
Yeah.
However, he took ownership of that. We had another contractor who was not interested in taking ownership, and so the applicant, who is rather elderly, is taking ownership. So, and that happens on a regular basis here.
Yeah.
I can think of somebody over on Avoca Drive that it happened to. So, George wants to speak, Herb.
Sorry, Mr. Burr.
That's okay. About 4 or 5 months ago, we met unofficially with the Board of Commissioners upstairs. Well, for the benefit of the city commission or the city fathers, this board, and especially our citizens, that 27% that was mentioned that day that we have rejected your recommendations versus other boards that had only 9.5%, I believe it was. That database, you have it, what we have rejected, in order for you to come out with 27%. Why can't we utilize that database, find out which are the most common ones that fall in the same line, and then pick up from those 2-3 lines that are repeating themselves, and then recommend it to the commission through the planning, Mr. Lecouris, and then to the commission. Why can't we follow that, and all of a sudden we say the staff won't spend time? That's already in the books.
Eric, I think that came from your office, because we did not do any analysis
That did come from our
for some time.
For you to say now that the city staff won't do it, it's already done.
Yeah.
Thank you.
Okay, well, let's do this. How about,
You and I can share that information.
or you could just ask Mark how he wants to approach that. He's
I'd be
the one
glad
that
to.
came up with this solution, so I would say ask Mark how he wants to approach
Got
that. If
it.
he wants to spend city time doing that, if he wants to pay our office to do it.
Right, and let me first apologize, Eric. I didn't mean to cut you off or to be rude in any way. I simply didn't understand that you were answering for Heather. If she'd have said, hey, I'm not going to do that, you do it. I get it, right? But I just didn't get that you were intervening before she could even answer the question, which is basically what he just asked, is wherever that data came from, why can't we, access that data? And it just seemed like that would be a simpler way. I wasn't trying to say, that somebody needs more work on them. I thought it would be easier if we could delineate that way. If we already have a list of approvals and we know that, just like that man said, this is something we need to look at. And I agree with that. So I wasn't trying to cut you off. I apologize. I wholeheartedly did not mean to demean you in any way. I was
do not
simply
take
trying
it
to
to
get
heart.
something across to Heather and didn't get it to happen.
All
So
right.
thank you.
Thank you for your apology. I
So-
do not take it to heart. Don't worry.
So I mean, honestly, what we would do in that case, Chris, is you've given me a list of 3. That's the first 3 I'm going to take to Mr. LaCourse, and then after that, we would be glad to pull whatever you guys want to pull and take a look at, what are the reoccurring themes. I can tell you fences were something that we dealt with. However, you guys held the line on fences, so you may not want to look at that section. But I know you guys did have some concerns with the 2 fence variances that we did see. So, I mean, I can certainly give you the broader themes on those. It's not going to be a whole lot of work to do, but it's not like I'm going to break it down. Well, you did this many and this. I'm not getting into that. What I will give you the broader themes based on what we see reoccurring. Swimming pools are a big one. Driveways are, I can think of about a half dozen off the top of my head for driveways that we've done in the last 2 years. And I'm not going to be going back much beyond those 2 years because the majority of you guys weren't sitting on this board at that time. So, the issues that were faced by previous staff, I don't know how relevant they really are to today. It's more of the issues that you guys have faced in the 2 or 3 years that I've been here.
And I'm thinking in the interest of being responsible stewards of our resources, we've given Heather and her team these 3 or 4 things to look at. That takes time, staff, and resources to do that. Our legal counsel has already created that other document with that analysis. So that's a good starting off point. And as part of being volunteers, if we can go back in our own notes and look to see, are there any other things that we want to bring forward, as opposed to asking, for an exhaustive.
It won't be exhausted. I mean, it's going to be
on your end. I mean, I just always try to be respective of those resources.
All of the applications we do per year add up to a little over 100 applications over the entire course of all the boards that we serve. So we're not talking about such a voluminous amount of information, but we are talking about, because you do so few. I mean, honestly, you guys think you do a lot, but because you're doing so few of those, I've been in jurisdictions where it's a lot more. And so, when you get into the discussion of 100, it's not necessarily 100 variance applications, it's hundreds of permits in the variances that do become before you. It's the majority of that percentage, which is a small percentage of all the building permits that we issue, that 1% that the attorney's office is getting to. It's not a 1 in 100 variance per applications. At least, Eric, I don't want to put that in there, but I don't think that was the intention. I think what Jay was trying to illustrate is we give hundreds of building permits a year. So as a result of that percentage, you're seeing a small percent, and then of that small percent that you do see, it should be a small percent that you actually grant the variance to. So the numbers are just like how often a 100-year storm event is going to occur in your community. It doesn't happen once every 100 years. It can happen once every year. For what it matters, it's illustrative of a point.
I hear what you're saying, and what you're saying makes logical sense, but I was pretty clear in talking, and I understood what he said. I really did.
Can we move on?
Yeah, that's fine.
On the question of emailing requested recommendations to Heather, I would like to know what people are recommending, but is there a sunshine law problem? Can we be notified if
Erica, what I can do is put it on their agenda as part of the board, because they'll come. It won't be coming before them, though.
It's not going to be coming before you. You guys don't make decisions on whether or not you should change the land development code.
Yeah,
but what I would suggest is, if you're going to email it to Heather individually, and then if something comes of it, she can email it to the board and say, these are the things, here's a list of the things that we received. That way you find out. But I would just prefer, I mean, you're not going to see changes to the land development code come before you. That's not your purview. That's the planning and zoning board.
But somebody might make a comment about a variance, and it might be an implication that it could come up before us again.
Yeah, I would, just for conservative and to make sure we're not getting into any mud here. Let's go ahead and whatever you email to Heather, she can certainly compile them and email them to everybody in one fell swoop, and then just do not reply all to that email. So if you're gonna just keep it between you and Heather, and Heather can disseminate information to the entire board. And then at that point, you can discuss it.
Emails won't state something like, I don't like to see all these driveway variances, let's make them as wide as possible, for example. And that comes to us, we now know how people think about these driveway variances coming up. I'm not so sure that's a good idea. How do we get around the
I
problem?
can tell you that the likelihood that the Board of Commissioners would grant a change of that, of substantial thing that I don't like it.
Example.
I
One
get it,
example.
but
Yeah.
it's highly unlikely that something
I
like
don't
that's
want
going
us
to
to
come.
be tainted by what people are saying to,
I agree.
about
So I
the
would
code.
say if you're gonna, if anyone is gonna email Heather, just email her directly, don't copy anyone, and then Heather can say, these are the list of code sections that I've been requested to look at changing.
Without
and that's
comment
it.
as to.
Without comment.
Just don't, when you do an email, just don't say, I object to
Don't hit reply
wide
all.
driveways
Reply
or
all.
parking.
There's your
Not hit
sunshine.
reply all, or just don't reply at all. Call. Use the telephone.
While we're on the subject, and I think you may be able to answer that.
Could you get on the microphone?
Yes. The chairman mentioned number 7 earlier on the driveway, that it may expand to other homeowners and so on and so forth, and it will change the whole thing in the area. Across the street from this driveway on 117 to 123, whatever the number was, it's a house number 202 on the west side of North Florida Avenue. That house has a driveway of over 35, 40 feet. Who gave permission to that homeowner the last 2 years to have that driveway there? He even has moved his mailbox with a big square post right on the pavement of the road. Nobody came here to get a permission for that. And nobody has looked at that. And that driveway is over 35 feet.
If you have a problem with that, I would suggest take that to code enforcement and notify them. They're the ones that can enforce that. If there is even an
It
issue.
goes back to number 7. That homeowner was able to do it. This one cannot do it for 3 feet or 1 foot, whatever the difference was.
You don't know, but that's the thing is, I don't, and maybe somebody does, but I don't know the circumstances of that.
I agree with that. But the point is this, you do not allow us to bring a case like that here
You
and
cannot.
find out what happened to that.
You cannot.
So that homeowner is shortchanged at that point because we can't discuss anything.
You don't know that, and that's not true. It's whether or not their application and the evidence that they present to you meets the criteria that's in the code. Whether or not the code is fair or not, or whether or not somebody else received a variance, or whether or not that doesn't even apply to them. Maybe their right of way, maybe that the width on their right of way is in compliance, and maybe they just expanded their driveway further up. I don't know their circumstances. I cannot answer that question for you, but I can tell you the law says you are only to consider the application before you. What somebody else has, it doesn't make a difference.
Okay. Could I clarify something here? I need to clarify that you mentioned about bringing it up to code enforcement. I've brought it up to code enforcement, and code enforcement for Tarpon Springs says they can only, they only have jurisdiction over something as it's being done. Once it's completed, they don't deal with it, and it has to go back to Anthony in building.
Well, Anthony's not the building.
That's not incorrect, Erica.
Yeah,
We
I
have a
was gonna say-
bifurcated code enforcement systems. Building stuff goes one place and,
Right.
and land
I
development code issues go to another place.
But if you notify code enforcement, one of the code enforcement officers can say that's not my jurisdiction, and they can relay it over to whoever the official will.
Or they'll send you to the building official.
I'm just saying that I've done that, and it's gone nowhere, so.
Well, there will be a new building. Excuse me, building development director.
Hopefully soon.
Yeah, that would be nice, because I've got.
One of the things that got approved last night was the job notice.
So until it's approved, then this loophole that's there against the homeowner that comes here, why can't we use that?
What loophole?
Well, Mr. Eisner says he went back to code enforcement, it went nowhere. Now, you're saying you're hiring a new building inspector or?
Building official, yeah.
Building official. That means the city doesn't have that.
Yes, we still have.
We have a building official on staff. It's just a contract with a contracted agency. We do not have a staff member sitting in the seat 5 days a week, going through everything that, that they do.
We're getting
Right now,
too
it's
deep.
on contract.
All right, we're getting too deep, it's getting late, that's fine.
All right, there's no further discussion. We're closing the meeting at 9:20. Thank you. Is there a meeting next month? Any ideas?
Yes.
Okay, thank you.
So there are ideas or there is a meeting?
There is a meeting.